Hi. Before understanding how even the oral partition prior to 2005 damages the women's rights in the coparcenary ancestral property, it is better to understand the brief context of this entire issue. In 1956, Hindu Succession Act was launched, wherein Section 6 speaks that, as of 1956, Section 6 speaks that only the male coparceners will be entitled for the coparcenary property. And out of those male coparceners, subject to 4 generations, if anybody dies, their family members will get the share of the coparcenary property by way of a regular inheritance. That is the regular rule of inheritance. A regular rule of inheritance means the family members, the mother, the daughters, sons and the widow will get the shares to the extent of the share of the deceased partner. Okay, coparceners means co-partners. Now after 2005 amendment, not only the males, the women also got equal share, and the law recognized the women rights also. So this is a brief understanding about coparcenary property. You have to simply remember that coparcenary property means a joint property held for 4 generations prior to the generation which is taken for counting. That is grandfather, father, son, grandson. That's it. Now granddaughters also, daughters, granddaughters also are eligible after 2005. Since 15 years, different high courts and the district courts and the lower judiciary was suffering with the interpretation of the amendment, because many transactions had taken place in the last 50 years. That is from 1956 to 2005. Many partitions were done, properties were sold, properties were leased out. A lot of things happened. Now, in 2005 amendment took care of that problem also. It clearly said that if the property was partitioned by registration in the sub-registrar office or through a court decree, then the daughters cannot question that property. This is what the 2005 clarified. But many of the partitions in India are oral partitions. Though Supreme Court in the judgment, which is in the description box, kindly go through it, which was delivered on August 11th, 2020, finally putting at rest to all sorts of interpretation that whether the father is alive or the daughter is alive, whether the daughter is married or the daughter is unmarried, whether the father is alive before 2005 or the father is alive after 2005, whether the daughter is alive before 2005 or whether the daughter is alive after 2005. All these interpretations were put to rest in the recent judgment rendered by Honorable Supreme Court on August 11, 2020. Now, Supreme Court also interpreted what is the meaning of the registration before the sub-registrar or through a court decree, partition through a court decree or partition before the sub-registrar. But the problem still which is in the entire country at large, in the villages and the cities, is the partition was affected orally, because nobody want to go out of the family and into the society and make it public. They want to simply enjoy the property without losing their respect. So many partitions are oral partitions. Now if there is an oral partition and if the daughter claims the right that denying the oral partition, what is the remedy that is left with the coparceners is the topic of this video. Supreme Court clarified that in the recent decision. Supreme Court clearly interpreted this angle of the oral partition also. What is the meaning of oral partition? So the parties to the partition, that is the coparceners, must act on the oral partition. What is the meaning of acting on the oral partition? That is, once partition is affected, they must either sell the property, they might have either leased the property, they might have either gifted the property, or they might have constructed something on the property. They might have mutated the names in the village records or the revenue records. They might have mutated the names in the municipal records. These are all the incidents of acting on the property. Now, if the coparceners or the male counterparts in the ancestral coparcenary property acted on that property, then the females cannot question, notwithstanding the plea that was taken by the male coparceners as oral partition. So not only registered partition before the sub-registrar office or the partition through the court, oral partition was also recognized by the Honorable Supreme Court, which will damage the rights of the women. So if the oral partition is genuine and if it is not played through the fraud, then women cannot claim the right the male counterparts may take through the oral partition. Okay, thank you. Thanks for watching. If you have any doubts, kindly comment.